Hello, this is the second lecture of our course Legal Foundations of Medical Practice, which is called Rights and Responsibilities of Medical Workers in the Process of Carrying Out Professional Medical Practice. When we speak about someone's rights and responsibilities, first we should mention the term legal status. And the legal status of any person, including a medical worker, is his legal position in the state and society, including his rights and responsibilities. The basis of the legal status of a medical worker is the rights and responsibilities enshrined in Articles 69-76 of Federal Law number 323 on the fundamentals of citizens' health protection in the Russian Federation. And we can distinguish the following types of legal status: general, special, and personal. The general status of a medical worker is a system of rights and responsibilities of all representatives of a medical specialty, regardless of the form of professional activity and the profile of the medical organization in which it is carried out. The special status of a medical worker is a system of rights and responsibilities that have specific features of specific medical specialties, for example, surgeons, therapists, dentists, including narrow profile specialists, neurosurgeons, cardiac surgeons, neonatologists, etc. And the personal status of a medical worker, it is also called individual professional status, is a system of rights and responsibilities of a particular medical worker in each specific situation upon providing medical services, medical care. In this lecture, special attention will be paid to the legal status of the physician as the main subject of providing medical care in Russia. According to Article 69 of the Federal Law on the Fundamentals of Citizens' Health Protection in the Russian Federation, the right to carry out medical activities in the Russian Federation have the persons who, first, have received medical or other education in Russian organizations involved in the educational activities, and second, who have passed the accreditation of a specialist. So, by other education, in this article is meant, for example, the education of a psychologist or a biologist. And if you speak about physicians, of course, they must have medical education. Thus, in order to work as a physician in Russia, you need to get higher medical education. And this may be, for example, educational programs in such specialties as general medicine, pediatrics, dentistry. This stage in the preparation of physician ends with the state-financed certification, and persons who have successfully passed this certification are awarded a diploma. And you need to pass the accreditation of a specialist. We will talk about this stage, about this procedure later in this lecture. So, let's speak about the situation when a person graduates from the university, receives a diploma, and does not want to or does not pass the accreditation for some reasons. In this case, he or she can be admitted to carry out medical activities in the position of a specialist with secondary medical education. In addition to such activities, may be admitted a student who has not completed the mastering of educational program of higher medical education, and this rule also applies to students and graduates from foreign educational organizations. The procedure of admission of the student or the graduate to medical activities in the positions of a specialist with secondary medical education is established by the order of the Ministry of Health of the Russian Federation dated the 1st of November 2022. And according to this order, the student or the graduate must pass an exam for admission to medical activities in the position of a specialist with secondary medical education. If a person finished 3 or more years of study in the specialties general medicine, pediatrics, dentistry, or received a diploma in these specialties, he or she may be admitted to carry out medical activities in the following positions: a nurse, a ward nurse, procedural nurse, nurse of the emergency department, district nurse, etc. And if a person finished 4 or more years of study in the specialty dentistry or received a diploma in this specialty, he or she may be admitted to carrying out medical activities in the position of dental hygienist. So if the position of a specialist with secondary medical education is enough for you, you may stop here. But if you want to work as a physician in Russia, then after graduating from university and receiving a diploma, you must pass accreditation. persons who have received medical education in foreign organizations are allowed to carry out medical practice after recognition in the Russian Federation of their education and qualifications, after establishment of compliance of the received education and qualifications with the qualification requirements for medical workers, and after passing the accreditation with specialist, unless otherwise provided by international treaties of the Russian Federation. So we see that accreditation is mandatory for all physicians who want to practice in Russia, regardless of the place where they got their medical education. So, you received higher education and successfully passed accreditation. Can you work as a physician now? Yes, but in accordance with the order of the Ministry of Health, dated the 8th of October 2015, there is a list of positions which you're eligible to hold. District General Practitioner, Physician of the Emergency Department, Specialist in Medical Prevention, District Pediatrician, General Dentist. As we can see, the list of specialties is quite limited, and in order to expand your professional opportunities, you have to undergo postgraduate education. So postgraduate education is designed to ensure the preparation of graduates of medical universities for their independent professional activity, professional development of the specialists, the training of specialists, taking into account the changing situation on the labor market, training of specialists for attestation, and introduction of new progressive technologies and methods of prevention, diagnosis, treatment, and rehabilitation to healthcare practice. Postgraduate education is carried out in the following forms. It may be the residency for in-depth study of the specialty for 2 years. And this form of postgraduate education is regulated now by the order of the Ministry of Education and Science of the Russian Federation, dated the 19th of November 2013. And it is the completion of residency program that is the main condition for admission of a physician to a wide range of medical specialties. After completing the residency program, you can work as a geneticist, as a hematologist, cardiologist, gynecologist, andrologist, and many others, which you may see on your screen. In addition, there are such levels of postgraduate education as a professional training program, professional development program, and these programs are organized in training cycles of different duration and forms. And of course, you may pass postgraduate or doctoral programs for the training of highly qualified specialists for medical science and education. They last for about 3 years. So we have already mentioned accreditation of a specialist as one of the main aspects on the way to medical practice. And accreditation is a procedure for determining the compliance of a person who has received a medical education with requirements for carrying out medical practice in a specific medical specialty. Currently, the accreditation is regulated by the order of the Ministry of Health of the Russian Federation, dated the 28th of October 2022. And there are following types of accreditation which may be distinguished. Primary accreditation, which is carried out in relation to persons who have completed the mastering of basic educational programs of higher medical education, specialist programs. Primary specialized accreditation, which is carried out in relation to persons who have completed the mastering of residency programs and professional retraining programs. And periodic accreditation, which is carried out in relation to persons who have completed the professional development programs. The accreditation of specialists is carried out by the Accreditation Commission, and they may include representatives of medical professional and profit organizations, professional unions of medical workers, organizations engaged in educational activities, federal government authorities or public authorities of the subjects of the Russian Federation in the field of health protection, and medical organizations. And on the screen, you may see stages of accreditation according to a specific type of accreditation. So you may see that in primary accreditation, testing, assessment of practical skills in stimulated conditions, and solving situational tasks are included. In primary specialized accreditation, testing and assessment of practical skills or solving situational tasks are included. And in periodic accreditation, only portfolio assessment is included. Now you may see on your screen all different types of accreditation which a specialist has to pass during his professional career. For example, if a person graduates from the university, receives a diploma, he has to pass primary accreditation. It is necessary for everyone. We have already spoken about this. After this, he may work as a district general practitioner, district pediatrician, etc. In this case, every 5 years, he has to pass professional development program. Then he pass periodic accreditation, and then he may work again as a district practitioner. Or after primary accreditation, a specialist may undertake residency program. In this case, after finishing this residency program, he has to pass primary specialist accreditation, and then he may work as a practitioner. And while he is working, every 5 years, he has to undergo professional development program, pass periodic accreditation, and then he may practice again. Or, for example, during his career, he may decide to undertake professional retraining program. In this case, after finishing this program, he has to pass specialist accreditation, and then he may work again. We spoke about accreditation, but one more procedure, which is very important for medical workers in Russia, is attestation. It is conducted voluntarily. Its legal significance lies in the fact that according to the results of attestation, a qualification category, second, first, or highest, is assigned. To be awarded the second qualification category, a specialist must have at least 3 years of work experience in the specialty. To be awarded the first category, a specialist must have at least 5 years of work experience. And to be awarded the highest qualification category, a specialist must have at least 7 years of work experience. The procedure and terms of attestation by medical workers for obtaining a qualification category are established by order of the Ministry of Health of the Russian Federation, dated the 22nd of November 2021. Attestation is carried out once every 5 years, but attestation for the assignment of a higher qualification category can be carried out as early as 2 years from the date of publication of the Act on the assignment of the qualification category. Qualification categories assigned to specialists are valid for 5 years from the date of publication of the Act on the assignment. During the attestation, the theoretical knowledge and practical skills necessary to perform professional duties in the relevant specialties and positions are evaluated on the basis of the results of the qualification exam. And the qualification exam includes an expert assessment of the report on the professional activity of a specialist, a test control of knowledge, and an interview. For carrying out attestation, special bodies are created, for example, the Central Attestation Commission, Departmental Attestation Commissions, and Territorial Attestation Commissions. The composition of these attestation commissions may include leading specialists of organizations engaged in medical and pharmaceutical activities, representative of medical professional non-profit organizations, employers, public authorities, other persons. And after receiving the document, the Attestation Commission reviews them and appoints the date and place of the test control of knowledge and the interview. And based on the results of the attestation of a specialist, the Attestation Commission makes a decision on the assignment or refusal to assign a qualification category to a specialist. Also, we should mention 2 types of physician according to the order of the Ministry of Health and Social Development of the Russian Federation, dated the 6th of August 2007, on approval of professional qualification groups of position of medical and pharmaceutical workers. According to this order, 2 levels of physicians may be distinguished: trainee physician and medical specialist. According to the federal law on the fundamentals of citizens' health protection in the Russian Federation, specifically according to Article 70 of this federal law, the position of the attendant physician is identified. The attendant physician is a person who has the main responsibilities for the management of a particular patient. The attendant physician is a physician who performs the functions of organizing and direct provision of medical care to the patient during the period of observation and treatment. The attending physician is appointed by the head of the medical organization or division of the medical organization, or he is selected by the patient with the consent of the physician. The attending physician organizes a timely qualified examination and treatment of the patient, provides information about the state of his health, invites specialist doctors, consultations, and, if necessary, calls a case conference of physicians. The attending physician establishes a diagnosis, which is based on a comprehensive examination of the patient, and a medical report about the patient's disease condition, including the cause of the patient's death. When we speak about rights of medical workers in Russia, we should say that medical workers have equal rights with employees of other professions. They're subject to general guarantees and compensations provided by the Labor Code of the Russian Federation. In addition, the Labor Code and bylaws adopted in accordance with it establish special guarantees for medical workers, for example, such as reduced working hours, additional paid leave for certain categories of medical workers, preferential retirement age, etc. These rights and guarantees will be discussed in more detail in the following lectures. Along with this, the law number 323 in Article 72 establishes for medical workers a list of special rights and incentive measures, namely, creation by the head of a medical organization of appropriate conditions for the employee to perform his labor duties, including providing the necessary equipment, professional training, retraining, and professional development programs at the expense of the employer, professional training at the expense of the employer's funds or other funds if it is impossible to perform labor duties for health reasons, and when employees are dismissed due to a reduction in the number of workers or in connection with the liquidation of the organization. Passing attestation for obtaining a qualification category, as well as for differentiation of salary based on the results of attestation. Incentive programs in accordance with the level of qualification, with the specifics and complexity of the work, with the scope and quality of labor, as well as specific results of activity. Creation of professional and profit organizations. Insurance of the risks of professional responsibility. The government of the Russian Federation, state authorities of regions of the Russian Federation, and local authorities have the right to establish additional guarantees and measures of social support for medical workers. When we speak about responsibilities of medical workers, first we should mention Article 73 of the Federal Law number 323. In this article, we see that medical workers carry out their activities in accordance with the legislation of the Russian Federation, guided by the principles of medical ethics and deontology. And here we should say about the Code of Professional Ethics of a Physician of the Russian Federation, which was adopted by the First National Congress of Physicians of the Russian Federation on the 5th of October 2012. Also, according to Article 73, medical workers are obliged to provide medical care in accordance with their qualifications, job descriptions, official duties, observe medical secrecy, improve professional knowledge and skills by passing professional development programs, prescribe medicines in accordance with the procedure established by the authorized federal executive authority, and inform the authorized official of the medical organization about side effects, adverse reactions when using medicines or medical devices, about individual intolerance and lack of efficiency, as well as other facts and circumstances which pose a threat to the life or health of a person when using medicines or medical devices. As I have already mentioned, medical workers are obliged to prescribe medicines in accordance with the special procedure. And nowadays, this procedure is regulated by the order of the Ministry of Health, dated the 24th of November 2021. According to this procedure, information about the prescribed medicine is entered by a medical worker in the patient's medical documentation. For example, such information as name of the medicine, its dosage, method of administration and application, dosage regimen, duration of treatment, and justification of the prescription of the medicine. A medical worker issues the prescription of medicine on a prescription form in two ways: on paper with his signature, or with the consent of the patient in the form of an electronic document. And the appointment of medicine is carried out by a medical worker according to an international non-proprietary name, and in its absence, according to a grouping or chemical name. International non-proprietary name, or INN, is intended to make communication more precise by providing a unique standard name for each active ingredient to avoid prescribing errors. Having standard names for each drug is important because a drug may be sold by many different brand names, or a branded medication may contain more than one drug. And on your screen, you may see international non-proprietary name and proprietary names of one active ingredient. In this case, it is paracetamol. In the absence of an international non-proprietary name and a grouping or chemical name of the medicine, it is prescribed according to the trade name. The prescription of a medicine is issued in the name of the patient for whom the medicine is intended. Medical workers are prohibited from making prescriptions in the absence of medical indications from the patient for unregistered medicines, for medicines that, in accordance with the instruction for medical use, are intended for use only in medical organizations, and if a prescription was issued in violation of these requirements, it is considered invalid. So, in addition, the law, precisely Article 74 of the Federal Law number 323, imposes restrictions on medical workers upon carrying out their professional activities. Medical workers and heads of medical organizations are not entitled to accept gifts, cash, including payments for entertainment and recreation from organizations engaged in the development, production, or sale of medicines and medical devices, and from pharmacy organizations, as well as to participate in entertainment events held at the expense of these organizations, but with the exception of payments under contracts on conducting clinical trials of medicines or medical devices, and payments related to the implementation of pedagogical or scientific activities by medical workers. Also, medical workers are not allowed to sign contracts with the company or representative of the company on prescribing or recommending medicines and medical devices to patients, with the exception of contracts on conducting clinical trials of medicines or medical devices. Medical workers are not entitled to receive samples of medicines and medical devices from the company or the company's representative for delivery to the patient, except for cases related to the conduct of clinical trials or of medicines or medical devices. Medical workers are not entitled to provide, when prescribing a course of treatment to a patient, unreliable or incomplete information about used medicines or medical devices, including hiding information about the availability of similar medicines or medical devices. Medical workers are not allowed to hold office hours for representatives of companies, except for cases related to the conduct of clinical trials of medicines or medical devices, participation in meetings of medical workers, and other events aimed at improving their professional level or providing information related to the monitoring of the safety of medicines and medical devices. And also, medical workers are not allowed to issue prescriptions for medicines or medical devices on forms containing advertising information, as well as on prescription forms on which the name of the medicine or medical device is printed in advance. If a medical worker is going to carry out activities as an individual entrepreneur or set up a limited liability company, then he has to receive a license. It is a state-issued document, and the process of its receiving is regulated by the decree of the government of the Russian Federation of the 1st of June 2021 on licensing of medical practice. The legislation of the Russian Federation provides criminal liability for illegal private medical practice. This liability is established in Article 235 of the Criminal Code of the Russian Federation. In order to implement and protect the rights of medical workers and develop medical activities, to promote scientific research and to solve other issues related to the professional activities of medical workers, they have the right to establish professional non-profit organizations on a voluntary basis. Professional non-profit organizations can participate in the development of norms and rules in the field of health protection, procedures for the provision of medical care and standards of medical care, training and professional development programs for medical workers. They also take part in the attestation of medical workers to obtain their qualification categories. Medical professional non-profit organizations that unite at least 25% of the total number of physicians in the territory of the subject of the Russian Federation have a special status. They have the right to participate in the conclusion of agreement on tariffs for medical services in the system of compulsory medical insurance and in the activities of compulsory medical insurance funds, as well as in the development of territorial programs of state guarantees of free provision of medical care to citizens. The implementation of certain functions in the field of health protection may be transferred to medical professional non-profit organizations, the associations, unions that meet the criteria determined by the government of the Russian Federation. One more aspect that we should mention is settlement of conflict of interest upon carrying out medical practice. So, conflict of interest is a situation in which a medical worker, when carrying out his professional activity, has a personal interest in obtaining, personally or through a company representative, a material benefit or other advantage that affects or may affect the proper performance of his professional duties, due to a contradiction between the professional interest of this worker and the interests of his patients. And the law establishes that if a conflict of interest occurred, a medical worker is obliged to inform the head of the medical organization in which he works about it in writing, and an individual entrepreneur carrying out medical practice is obliged to inform the Ministry of Health of the Russian Federation about this situation. One of the most significant traditions accompanying a physician into professional life is the oath of a physician of Russia, provided in Article 71 of the Federal Law on the Fundamentals of Citizens' Health Protection in the Russian Federation. The oath of a physician is given in a solemn atmosphere by persons who have completed the mastering of the educational program of higher medical education upon receipt of a document on education, a diploma. This oath proclaims: receiving the high title of physician and embarking on professional activity, I solemnly swear to honestly fulfill my medical duty, to devote my knowledge and skills to the prevention and treatment of diseases, preservation and strengthening of human health, to be always ready to provide medical assistance, keep medical secrecy, treat the patient thoughtfully and carefully, act only in his interests regardless of gender, race, nationality, language, origin, property and official status, place of residence, attitude to religion, beliefs, membership in public associations, as well as other circumstances. To show the highest respect for human life, never carry out euthanasia. To keep gratitude and respect for my teachers, be demanding and fair to my students, promote professional growth. To treat colleagues kindly, ask them for help and advice if the interests of the patient require it, and never refuse colleagues help and advice. Constantly improve my professional skills, protect and develop the noble traditions of medicine. Summarizing the above, we should note that the main rights, responsibilities, guarantees, and restrictions regarding medical workers, as well as incentive measures for them, are provided in Chapter 9 of the Federal Law on the Fundamentals of Citizens' Health Protection in the Russian Federation. And the legal regulation of healthcare worker status has certain features which are established by regulatory legal acts.